Manever I say ma PENDREAM TV. PENDREAM TV there, I see them yopo.
First of all, in discussing this matter, I think it's important to apply the lessons of history. In addition to that, it's extremely important for us to look at issues of principle. What principles are we applying in this matter? And then, ultimately, we have to test for consistency. It's important that we test for consistency. Now, first of all, if you take history, and you want to look at history from 1992, the first president to apply Article 146 of the Constitution is President Nana Addo Dankwa Akufo-Addo. The first president to apply Article 146 of the 1992 Constitution is Nana Addo Dankwa Akufo-Addo. In his case, Article 146 was used to dismiss two public officials who had the status of judicial officers. The first case had to do with the chairperson of the Commission on Human Rights and Administrative Justice, who was removed from office based on a petition which is very, very similar to the one we have just discussed.
I think that was under President Mahama.
Yeah. Okay. Yeah, no problem, no problem. I would concede that. But the petition was very, very similar. And indeed, the petitioners included a member of parliament of the New Patriotic Party, and not Domprey. You understand? So that's important. It's important to establish that. Then there was the case of Madame Charlotte Osei, who was the chairperson of the Electoral Commission. Now, for me, one of the most significant things is that in these two cases, none of us knew the contents of the petition which was sent to the president. In fact, as we speak, we don't even know the names of the petitioners. None of us knew the content of the petition, and we didn't know the names of the petitioners and so on. And in fact, under President Akufo-Addo, the claim was that as soon as the president receives a petition for the removal of such an officer, he acts as a conveyor belt or a post office and simply passes it on to the Council of State. That was the argument. Okay. So, we are not dealing about an issue for which there is no precedent. We're dealing about an issue for which there are precedents, at least two precedents. One, as you say, under President Mahama, and one, as you say, under President Nana Addo Dankwa Akufo-Addo. So that's the history. Now, it is important for us to understand that judges, especially judges of a certain caliber, play God. Judges, they are so very powerful. They can decide whether you should live or you should die. They have the power to sentence people to death. I lived in the Southern prison on a number of occasions. And I see prisoners who have been condemned to death. who made that condemnation? Judges. Judges sat, listened to their cases, and decided that they should die, they should be killed. Judges decide that they should be hanged by the neck until they die. Very powerful. Now, people who are able to take life, legally take life, people who are able to sentence their fellow men and women to death, people who are able to decide that some people should be shot by firing squad, they have to have a very high level of moral standards. You can kill. You can order that people be killed. So you must be an angel. Your standard must be next to God. You understand what I'm saying? So if we, the people of Ghana, through our constitution, through the institutions established by the constitution, give you power to decide who should live and who should die, you must be an extraordinary person. You understand? And that is why, for me, this whole argument about threshold and so on annoys me to bits. Because we are dealing with the Chief Justice. We are not dealing with Suhini. I mean, the Chief Justice's standards, moral standards, ought to be higher than that of an MP. The moral standards of a Chief Justice ought to be far higher than all of us sitting around this table, because of the extraordinary powers that we have given them. You understand? So, when they talk about threshold, what are they talking about? And indeed, who has determined that threshold? In this constitution, 1992 constitution, does it set any threshold for misconduct? And if it doesn't, whose threshold are we using? Is it the threshold of a retired Chief Justice, or the threshold of Ibrahim Musa, who is the security guard at Roman Ridge, or the threshold of the truck driver whose threshold is being used? Under what law has that threshold been established? So that whole threshold argument really is not even worthy of consideration, because it gets reduced to individual perceptions, individual standards, individual opinions, and so on. And no nation can be built on this basis. So those who argue on the basis of threshold should come and show us how that threshold is established or was established, and what that threshold is. The Constitution is clear. The Constitution clearly talks about stated misbehavior. It doesn't say stated big misbehavior or stated small misbehavior. It simply says stated misbehavior. Now, those who want to add values to misbehavior should come and tell us which misbehavior is big or high, which misbehavior is small or low. Until they're able to establish that, they should stop wasting our years on this matter of threshold. You understand? Now, Suhini, on 7th January 2025, I didn't go to the Black Star Square. In fact, I've never been to a presidential inauguration.
Oh, really?
Okay, never.
Not even as a journalist.
Pardon?
Not even as a journalist.
No, never been to a presidential inauguration. In fact, it's not worth it. You understand? But I watched it at home. I watched the whole ceremony at home. And there's something which is very striking about what happened on 7th January 2025. President John Dramani Mahama took the oath of office. That oath of office was administered by Justice Torkornoo. If I lie, tell me. And what was the oath of office? That he would defend and uphold the Constitution of Ghana, so God should help him. And Justice Torkornoo is the one who administered that oath. When she was administering that oath, was she expecting the president to breach the oath of office? Because that oath meant the Constitution in its entirety will be defended, not just defended and upheld. That included Article 146. So how is she, and I'm not talking about the people of Ghana, I'm not talking about all of us, Justice Torkornoo, who administered that oath of office, how can she now be expecting the president to do things contrary to what is stated in the Constitution, specifically Article 146? I cannot believe it. But you see, some things have come to our attention. And one of the things which has come to our attention is simply the fact that apart from the members of the committee who looked into this matter, and you cannot take that membership lightly. Yes. One, the chairperson of the committee is a Supreme Court judge himself. You understand? And if judges have an interest in protecting the judiciary and so on, what is it that tells us that Justice Torkornoo, more than Justice Puaman, is more interested in protecting the judiciary than Justice Puaman? Why? How can you make that argument? Okay? But the committee was chaired by Justice Puaman, and from what I have learned, Justice Pratt was on the Supreme Court before Justice Torkornoo. So even in terms of seniority, Justice Pratt is senior to Justice Torkornoo. Not be so. Yes. So Justice Pratt was chairman of this committee. Then there was another Supreme Court judge who was a member of the committee. Two Supreme Court judges were members of this committee. In addition to that, the head of Ghana's audit service, the former head of Ghana's audit service, former Auditor General of Ghana, Auditor General of Ghana, was a member of this committee. Three of them. One of them is a serving military officer. And another one, I can't. A professor at the university. This is the composition of the committee. Don't forget the composition of the committee. Keep it in mind. Because we might come back to the composition of the committee. But keep it in mind. Now, the committee did not treat this matter lightly. Nobody can argue that this matter was treated lightly. The committee examined, and I mean examined, 10,000 pages of evidence. Can you imagine what 10,000 pages of evidence is? This whole book, Constitution, is how many pages?
Up to 500.
The whole Constitution is 210 pages. The whole Constitution that we've been discussing and so on is 210 pages. But this committee looked at 10,000 pages of evidence. Wow. The former Chief Justice, Justice Torkornoo, called 13 witnesses, 13, including experts. The 13 witnesses she called included 2 former Supreme Court
Chief Justice.
2 former Chief Justices. Bear all this in mind. The petitioner also called 12 witnesses, including experts. So between the Chief Justice and the petitioner, they called 25 witnesses, including experts. 25 witnesses, including experts. Justice Torkornoo went to the committee with 4 lawyers, which included a former Attorney General. Master, I hope you guys are taking note of these very important facts. The petitioner also went to the committee with 4 lawyers. Hey, babe. How could this matter have been treated so lightly? So the suggestion that this matter was treated lightly is simply untenable and unacceptable. Now, all the discussions that we have had so far, nobody, and I mean nobody, has even remotely suggested that there has been abuse of process or that any law has been violated. If you've heard any, say it now. Tell me. Nobody.
Nobody.
Okay. So, in effect, what opponents of the president are saying is simply that the president should have ignored constitutional provision. He should have broken the law. He should not have kept his oath of office. That's what they are telling us. But that is shocking, because these are the same people who make noises about the rule of law. Not so. When they talk about the rule of law, what do they mean? That the law must guide us in everything we do. And that whenever there's a dispute, we should make reference to the law. Whenever there's an issue to be determined, make reference to the law. Let the law decide. And indeed, Justice Torkornoo herself believed that principle. That is why she told us with a smile, with a lovely smile, that the law is the law. Since when did the law stop being the law? The law is the law and is the law. She said it. She wasn't angry when she was saying it. She said it with a broad, beautiful smile. Now the law is the law, and we are complaining, saying, hey, why do you apply the law? So what should we apply? If we shouldn't apply the law, what then should we apply? Master, this case is interesting. Article 146 says very, very clearly that everything should be in camera. About this process should be in camera. So what the petitioner submits is not to be made public. It's in the article, Article 146. You can open Article 146 for me and I'll read it for you. That it should be in camera. But interestingly, the Ghana Bar Association, not the Shoemakers Association of Fafraha, the Ghana Bar Association came and told us that the petition should be disclosed, should be made public. Ghana Bar Association. I mean, what kind of society are we building? The Ghana Bar Association says we should violate the Constitution. We should make the petition public. Lawyers, who, not carpenters, not surgeons, not philosophy professors, lawyers, came and told us that we should violate the Constitution. Hey, babe, where are we going? That should be made public. Now, as I said from the very beginning, none of us know what was contained in the previous petitions because of the strict adherence to the constitutional provision which says that the thing should be in camera. In this particular case, everything or most things were in the public domain. Even the place where the proceedings were being held, the history of the place, the concocted, distorted history of the place where the proceedings were being held was in the public domain. Now, for me, who put these materials in the public domain? Who put these materials in the public domain? To answer this, you have to ask the question, who benefited from these disclosures? Or who thought that they could benefit from these disclosures? And if you ask these two important questions, the people who leaked the information is clear. And I'm not even going to mention them because everybody knows who leaked the information. Who benefited? Who believed that they could benefit from these disclosures and so on. Now, interestingly, there have been claims that the Chief Justice has not been treated fairly. Okay. One of the grounds for making the claim that the Chief Justice has not been treated fairly is that the Chief Justice's husband was not allowed into the proceedings. In-camera proceedings. We didn't allow the Chief Justice into the in-camera proceedings. And the Chief Justice herself says that, look, she needs the husband for her stability, for her mental stability. Chief Justice, who needs the presence of her husband for her mental stability, is a problem. For, not mental, psychological stability. So when she's sitting in court over very controversial, crucial, important national decisions and so on, what would her husband be? Sitting behind her in the Supreme Court to give her psychological balance? I mean, that position alone should disqualify her from being Chief Justice. Her own admission that for her to get psychological stability in moments of stress, she needs her husband's presence. It's a big blow to her qualification as Chief Justice. You understand? Pardon?
She doesn't wear the rope with her husband. We didn't rope her with her husband. The state didn't rope her as Chief Justice with her husband.
Because we didn't know that without her husband she suffers. She has problems. No, she didn't tell her the better. The husband. Because if we knew that she needs the husband in moments of stress and so on, perhaps we would not have made her the Chief Justice. But this is her own statement, her own statement, that without the husband, hey, trouble come. Then, for me, the worst part, when the Chief Justice held the press conference and said that she's traumatized. She's traumatized because of the venue of the proceedings. And that Amatekwe met Captain Chika out there some time ago. So because of that, when she enters the venue, oh my Jesus, Susum Kabri arrives. Hey, is this a Chief Justice we're expecting to be fair to all manner of people? She gets traumatized when a particular name is mentioned. So the other time I asked, if you appear before this Chief Justice, and for some strange reason your surname is Kwesi, what will happen to you? What will happen? Because she will lose her psychological balance. she will see you as the devil incarnate. You understand? So that also raises substantial questions about her ability to be impartial and her ability to rise above prejudice. This is self-condemnation. You understand? Be that as it may, the Constitution has been followed, and nobody is saying that the Constitution has not been followed. And a certain decision has been arrived at. I listened to Madame Sophia Akufu, and she argues that the problem is with the writers of the Constitution. The problem is with Article 146. That 146 gives too much power to the executive and perhaps the Council of State and the committee which is established to go into such matters. But then I ask, in the case of Charlotte Osei, it is the same Article 146 which was used. When she was sitting as Supreme Court judge to determine whether or not there was a prima facie case against Charlotte Osei, did it strike her that there was something wrong with Article 146? And if it struck her that there was something wrong with Article 146, how then did she manage to proceed with Article 146 as a guide to kickstart a process which led to the removal of a chairperson of the Electoral Commission? She didn't know then that there was a problem with Article 146. She only got to know it last week. Incredible. I mean, incredible. Clearly incredible. Okay? Then there's another aspect of this case which is interesting. You see, Madame Sophia Akufu, I mean, to all intents and purposes, is a highly respected woman in Ghana. And given the gender imbalance in our society, I think all of us have a responsibility to protect her integrity, you know, and to encourage her to continue to play the role that she has played as a stateswoman and so on. We have that responsibility. At least coming from the gender point of view and so on, we have a responsibility to protect women who get into high office. But you see, we must be assisted by those women too, to be able to stand up for the rights of women, especially the right of women to occupy any public position. I hope you understand what I'm saying. So, Madame Sophia Akufu is a member of the Council of State. And before admission into membership, they take oath of secrecy. Her current conduct, how does it play with the oath of secrecy that she took? I am not as privileged as Solomon Owusu, who says that he has seen the proceedings of the committee and so on. But she appeared before the committee as a witness in a case which was dealing with a matter which had been presided over or which had come before the Council of State in confidence. So before the committee, what was she talking about? Something she had taken part in deciding at the Council of State. She was ready to go and discuss it at another committee. What does that mean? What conflicts arise out of this? You understand? I read a statement which was attributed to her, and I must be careful, because these days it's not all the statements we see in the media which are correct quotations and so on. But I read a statement in which she's complaining that what she said in the committee had been made public. She's complaining bitterly. Who made it public? That is unethical to have made what she said in the committee public and so on. First of all, I'm not so sure that she should have gone to the committee. given her role as a member of the Council of State. But having gone to the committee, her complaint is that what she said had been made public. Who made it public? Was it President Mahama? No. Could it have been the petitioner? I doubt. Who made her statement public and so on? You see, in all of this discussion, the best commentary I've heard has been commentary from Nana Akumia, former communications minister, a member of the Baumia campaign team. I hope he's still a member of the Baumia campaign team. You know, former head of the State Transport Corporation and so many other titles and so on. And I heard him last Tuesday on Peace FM. And he said, no law has been broken. The Constitution has been followed to the letter. If he has any problem, it's with the drafters of the Constitution. That's what he says. Now, the Constitution having been drafted, having been promulgated, we held a referendum on it and so on. If there are aspects of it which, in my estimation, in your estimation, are not correct, are we going to encourage the president to violate them? So what are we talking about? I think case closed.
Dedi kama mamena PENDREAM TV ase. Na so far so good. Say open online portal e wo Ghana. Nipa share, nipa follow, nipa comment here. To my best of knowledge, without any biases, PENDREAM TV.